So let's get into the ins and outs of this case with Pilar Prince, a trial attorney. Anahita Sedaghatfar is a criminal defense attorney as well. This is an unusual case. The U.S. government would have to allow this lawsuit to proceed, right, Anahita?
Right. That's why they're going to court. And I think the court's decision here is going to be very critical, John, because if they allow this case to move forward, what it would mean is that the U.S. Constitution in certain instances would apply to somebody who's not a citizen, and even if they're on foreign soil. So this is a very critical decision. And remember, though, the court is not making a decision on the merits of the case. They're not going to say whether or not plaintiff wins or loses. The sole issue before the court is whether or not his family has standing to sue in this court system, in the United States court.
And as I understand, it would seem, Anahita, if this thing is allowed to proceed, that Border Patrol agents, I mean, it would have a chilling effect on the way they go about doing their job, wouldn't it?
I actually agree with that, and that's what a lot of critics are saying here, because they're saying, look, Border Patrol agents, they have to act in the heat of the moment. They have to make split-second decisions. And now, if they're going to hesitate to use force, even when it's necessary, even if they need to use deadly force, if they're going to hesitate because they're afraid they're going to be dragged into a civil court and sued for millions and millions of dollars, then they're putting their own lives at risk. Not only their own lives, but the lives of anyone else.
Why shouldn't they have the exact same? Why shouldn't?
Well, that's the issue. Should he be extradited to Mexico and face the laws in Mexico? Or should he be, allowed to be sued by someone who's not a citizen for something that took place not on U.S. soil in our country? So I think that's why this is going to have a huge impact with the court rules in this case.
He said, the board, right. Fascinating case, but it does seem that, if this goes through, if the court lets this go through, border agents are going to be looking over their shoulders every time they do anything on the job.
That's right.
Yes.
There is another controversy to talk with you about over just how much access schools should have to students' social media accounts. The law that makes it okay, in fact, makes it a requirement for administrators to demand passwords of their students. Our legal panel is going to take a look at that next. Law is giving school administrators access to their students' social media accounts. School districts and universities in Illinois, under a new state law, can now demand their students' passwords. Officials say the law is aimed at stopping cyberbullying. Critics say it goes way too far. Let's bring back our legal panel. Pilar Prince, a trial attorney. Anahita Sedaghatfar, a criminal defense attorney. All right, so if I am a school administrator in Illinois, Anahita, and I think that maybe little Jimmy over here is breaking school rules, maybe bullying some other kid, I can go to his parents or go to the kid himself and demand his password to his Facebook account?
That's right. And I believe that we do have an issue with cyberbullying. We've had cases where teens have killed themselves because they were being cyberbullied. So that issue needs to be addressed. But this law, I think, goes way too far. It's a total invasion of privacy, because it's one thing for the schools to monitor the social media posts of their students, to monitor their Facebook posts, their Twitter posts, whatever they're posting publicly. But to say that the students are required to turn over their passwords when there's absolutely no warrant, no probable cause, and to say that if they don't turn the password over, they can be held criminally liable, I think that's totally ludicrous, because there is a ton of private information contained in people's social media accounts that have absolutely nothing to do with cyberbullying or bullying another kid on campus, and schools shouldn't have unfettered access to that information without at least a warrant.
And Pilar, it doesn't appear, if, according to my understanding of the law, all that it takes is for school authorities to have a reasonable cause to believe that the kid was violating school procedures. Is that enough, Anahita? If I'm the principal and I think, that so-and-so posted something mean about her friend, I can just demand the password?
That's a very low standard. In fact, that's a much lower standard, actually, that police need in order to get a warrant. They would at least need some reasonable suspicion. And again, they're gaining unfettered access. And if the goal here really is to stop and curb cyberbullying, John, I'm not even quite sure this law is gonna do that, because teenagers are very, very savvy. They're very tech savvy, and they have ways to make anonymous accounts or accounts with different pictures on there so it can't be traced back to them. In fact, that's what usually happens in these cyberbullying cases. People don't use their own accounts with their own names, so there just has to be a less restrictive way to resolve this issue rather than having a law like this.
We're going to have to leave it there. I'm sorry, Pilar, we're running out of time, but good discussion.
That's okay.
We'll see where this goes from here. Anahita Sedaghatfar, Pilar Prince, thank you both.